Hi everyone, this is Sean. Welcome back to my channel. In today's video, I'm going to answer a question from one of our subscribers named Ed. And Ed wanted to know more about the California appellate case of Marois versus Royal Security and Investigation. I'm going to just summarize the case, but I will ultimately leave a link in the description so that you can review it. It's a very long case, you guys. It took me maybe about 45 minutes, maybe 30 minutes to read over the case, to analyze it. So anyhow, you guys already know my disclaimer. I'm not an attorney. This is not legal or professional advice. This is just my interpretation of the case study, of the case law. So this is a strange case. We have a security company that's assigned to protect Jack in the Box, two armed security officers. If you are assigned a post that requires two armed security officers at the Jack in the Box, because this is a Jack in the Box, you already know you got a screwed up post. Anyhow, they're assigned to the post. They watched this one fellow drunk, causing a scene, yelling obscenities, and they tell this guy, hey, get out of Jack in the Box, get out of here, you're not welcome. So he goes out into the parking lot. You guys already know what happens when you kick someone that's drunk out of a restaurant or a Jack in the Box. What happens? Well, they cause a scene somewhere else. So this guy gets a hold of a baseball bat, and in that same parking lot starts smashing windows, screaming and everything. And then we got these two fellows that are in the drive-thru. Oh, by the way, our two armed security officers, they call the police. They call the sheriff's department. Hey, get over here. We just trespassed this guy. He's causing a scene. He's not leaving. Can you guys send some officers or deputies over here, please? So these two random guys in the drive-thru, they leave the drive-thru, and they want to be good Samaritans, right? So they go over there to where this guy that's causing the scene is, and they tell him, hey, dude, knock it off. So what does a guy with a bat do when two guys tell him knock it off that's drunk? So he comes after the good Samaritans and swings a bat, gets into the altercation, and injures one. So that good Samaritan, later on, he was obviously injured. He sues Jack in the Box, and he sues the security company. His argument is that the security company and Jack in the Box have a duty to protect. The argument is that these armed guards, these armed officers, should have physically intervened. And because they have the power of a citizen's arrest, sorry guys, I'm over here in the desert and I'm trying to look at my surroundings here. But because they have the power of citizen's arrest, they should have executed those powers. Anybody has the power of citizen's arrest, including those two guys that were in the drive-thru. They have the power of citizen's arrest. So Jack in the Box settles. Okay, they don't want anything to do with this. They settle. Security company fights this case. Trial court basically rules in the security company's favor, and the plaintiffs, which is the guy that got injured, brings this case to the California Court of Appeals, and it's heard by the justices of the appeals panel. This is the interesting thing. So the Court of Appeals in California said that the question of whether or not the guard's actions were reasonable is not a question for a judge. It's rather a question for the jury. So the case law that we find today is not that the security guards have a duty to intervene, that they have a duty to physically intervene as well. No, that's not the topic, or that's not the issue at large. The issue is whether or not they have a duty to intervene. Whether they acted reasonable, the issue is whether or not they acted reasonable is a question for the jury. So what I don't want you guys to do is grab this case, show it to your boss, show it to your employers, show it to your coworkers, and say, hey, we as security have a duty to intervene, because that's not what the case is. No, the case is that if there's a question of reasonableness with regards to a guard's actions or even a private investigator's actions, that's a question for a jury to decide. So this case should have been heard by the jury and not granted summary judgment. Okay? Let me know what you guys' thoughts are about this case. I just think that this is ridiculous. I mean, this is one of those California cases they just sound ridiculous. However, once again, the justices on this panel, they did not view whether or not the security officer's actions were reasonable. Rather, they determined that the jury should interpret the evidence. They should be the ones to determine whether the actions are reasonable or not, which is kind of scary. Let me know what you guys' thoughts are on this. Looking forward to the dialogue. Take care.